This is your judgment, Justice, in the first one. I'm not talking about the rescission. The judgment was simply this. If you do not apply, the most abiding thing about your judgment was that if you are going to deny somebody Section 35, their Section 35(3) rights, and if you are going to deny their Section 12 rights, then at the very least you must apply Section 36. And that should be so obvious to anybody. And that is why in your judgment you then went to all the Section 36(1) criteria. You obviously did not, and the second thing you said was that the matter should have been referred to the NDPP. So you're quite right, Justice Theron. Whether after that referral he was going to go to jail, we will never know. So, but the point is that you correctly said, as in the PW Porter case, the matter should be tried in the normal way, and it should be. Mr. Zuma is not complaining so much about going to jail. He's been to jail many times. What he's complaining about is being to jail without a trial, without ever standing in front of someone and being asked, are you guilty or not guilty? That's all. So, correction made, but that's exactly what, and Justice Chafta's second judgment went further in the rescission matter, which you agreed with. And it was that not only is this a breach of the Constitution in South Africa, but it's also a breach of the international protocols, particularly Section 9 of the United Nations Charter.
I think you were still busy with the second one.
Yes.
Yeah.
Oh, yes. If you remind me, Justice.
I actually don't know what the second one was. I can't read your mind.
Neither do I. I think your first point was interpretation, which we've dealt with, and then it was the issue about the judges make mistakes. We've dealt with that. The third issue that you raised was the ambit of the exercise before this court, and I think we've also dealt with that thing.
I just want to test that with, and that'll be my last question. I just want to test what you've just submitted to me, and I hear you, but I just want to test that. One of the things that is raised in the Commission's heads on their written submissions is that the doctrine of stare decisis required the Electoral Court to follow the SCA decision in the, just for ease of reference, the medical parole appeal. You know the case?
Yes, the medical parole case. Yes.
One of the amici there, Institute of Race Relations, put before the court there an argument that Mr. Zuma is not a sentenced offender,
right,
for certain reasons, and therefore it doesn't qualify for medical parole. The court in its paragraph 24 roundly rejected that.
Yes.
That was one of the parts of the ratio decidendi of the court. So it's binding on the Electoral Court. Now, let's just park that there. What is the difference between a listed judge like me and an unlisted judge? It sounds like the JSE now, but anyway, like an unlisted judge like Justice Matopo in deciding that particular point?
No, the role is the same. The only issue is whether you, with respect, Justice Majid, are more likely in the eyes of the litigant to, for example, to cite that as an example that shows that the sentence was a sentence, so to speak, or an unlisted judge. And surely the perception of the reasonable perception of the litigant is that an unlisted judge is more likely to approach that very question that you have posed with a more open mind, because it doesn't really say anything about what they did or did not do. So that's the nub of the issue. Remember that one of the grounds that we raised, by the way, is the fact that, which informs Mr. Zuma's reasonable apprehension for an example, is the fact that that court that you're talking about, Justice Majid, made the finding that a person serving parole is not serving a sentence. And there's this court has said so many times that that is not that cannot be true. And in that case, Justice Mhlanhla and Justice Theron were sitting when it came back here, and all Mr. Zuma was saying was, I want leave to appeal on this notion that serving a sentence under parole is not serving a sentence. And this court rejected that. Not rejected whether it's A or B, rejected to even hear it. Just to hear whether or not its own judgment. This is the court that had said, in the case of Phahla versus Minister of Justice, parole is still a manner of serving out one sentence. This very court, you'll find that at paragraph 17 of our heads. It is therefore still a punishment, although a lesser one than imprisonment. It still amounts to a deprivation of liberty for a set period, albeit outside prison. Parolees remain subject to the supervision and authority of the department for the remainder of their sentence. That it mitigates a sentence of imprisonment does not detract from this. The very same court which said that unanimously refused to hear an appeal based on that notion when Mr. Zuma was concerned. So these are issues where it's difficult even for me as his lawyer to explain. When he says, but why won't they at least hear? They might disagree with me in the actual appeal, but surely they must hear it when it's about their own judgment. So all these things play a role, Justice Machit, in the overall perception. Perception is not something you can pick out and say here and that. It's a perception.
Yes, thank you. Thank you, DCJ.
Mr. Mpofu, good morning.
Justice Campbell? Sorry.
Your argument this morning is far more refined than that which is set out in the heads of argument.
Well,
and you've asked us to focus on the perception. I'm not sure whether it's a subjective or an objective perception, but the perception of a lay litigant. That's as I understand your argument this morning. Do I have it correct?
No, you don't have it correct. If you're not sure whether it's a subjective or objective, then you don't have it correct. I said the reasonable apprehension of a litigant in their position. So there's no doubt as to whether that's objective or subjective.
Very well. The second respondent is not a lay litigant.
The second
respondent is not a lay litigant. He was the former head of state, and he exercised the powers that the head of state exercises under Section 83 of the Constitution. That includes the upholding of the Constitution, and it included, in his time, the appointment of judges, both in the High Court and to this court. In that capacity, he would have understood what the oath of office of judges is. And the oath of office is the same whether you're in the High Court or the Constitutional Court. Does that change his perception as a litigant before us because of his knowledge of what judges are supposed to do and how they're supposed to behave?
No, the answer is to the two questions is no and no. One is the fact that you are a head of state or a premier or whatever cannot affect your status as a lay litigant, in the sense that when Mr. Zuma was being processed, to put it mildly, by this court, the idea was that he had disobeyed a court order. And that would apply to whether you're a head of state or a sweeper or whatever. It applies to you. The second issue is this. The test of the reasonable litigant is not tested like that. And even if it were, let's say for argument's sake, Justice Campbell, that was the case with Mr. Zuma. What about the MK Party? The MK Party was not a head of state. But it's a litigant in front of you. And the MK Party's perception is that this matter, because remember, it was after all the MK Party that was in front of the Justice Pillay panel. It was not so much Mr. Zuma. So that is a litigant as well. And to suggest that the MK Party was a former head of state would be stretching it a little bit.
Mr. Mpofu, I specifically referred to the second respondent.
Yes.
Because I understood from the affidavit filed yesterday that the first respondent has distanced itself from the second respondent, and the first respondent has indicated that it will abide the decision of the court. That's why I specifically focused on the second respondent.
Yeah, no, firstly, there's no such thing as the first respondent distancing itself. A certain Mr. Jabulano Kumalo, without, as the Deputy Chief Justice explained, without putting any proper papers, has put an affidavit to say that Mr. Zuma's claim to the presidency of the MK Party is false. But you can go through all these papers and show me where do we say Mr. Zuma is the president of MK Party. You won't find it. So what has that got to do with what we're busy with here? That's just an unnecessary distraction and publicity seeking. So let's please not be distracted by that. But assume, for argument's sake, that he's right, and therefore the only litigant in front of you is the MK Party. My answer still holds. So I don't see how on earth it could assist the assessment of this question, even apropos the MK Party only. In fact, it's even worse, because against the MK Party, the proposition that you are putting, Justice Campbell, of head of state doesn't apply. So it makes it our case even easier if it's just the MK Party.
Mr. Mpofu?
Yes.
I just want to come on the Pantla matter.
Yes, Justice Mhlahla.
It's correct that we said that parole is a form of punishment.
Yeah.
But the matter that came before the SCA was a question of whether the medical parole that was granted to Mr. Zuma was appropriately granted in terms of the procedure.
Yes.
And the SCA said it was not.
Yes.
That is the application that came before us.
Yes.
And we dismissed that application.
Yes.
We did not say parole is not a form of punishment. No. I just want to correct that. You can read the judgment of the SCA from para 54, 55, where it says, while these factors may well be taken into consideration in an application for normal parole, they have no bearing at all in an application for medical parole. So I just want to correct that your statement.
Thank you, Justice Mhlahla. Well, if I may, with your permission, also correct you. Yes, that was the nub of the issue. But that's not why, everyone knows, that's not why Mr. Zuma approached this court. Mr. Zuma, if it was all the niceties about parole and definitions and so on, he probably would have let it go. The reason why he came here was because in that court, at paragraph 60 of that judgment, it says that irrespective of the fact that the 15 months had elapsed, he had to go back to escort prison and serve the rest of his sentence, irrespective of the fact that that was clearly wrong on the Pahla test. That's why he came here. And fortunately, I drafted the application for a leave to appeal. What I just read out was quoted in that application to say the suggestion that despite having finished the 15 months, Mr. Zuma must go back to serve the remaining 9 months is flies against the partial theory, and that's what this court said is not should not apply. And it can be, Justice Mhlanhla, that we just choose the other theoretical issues. Yes, whether the thing was lawful or unlawful. By that stage, that was water under the bridge. Because remember, Justice Mhlanhla, that by the time those debates were taking place, the proverbial clock had already ticked. I think until it was October, the expiry was October 2022. So the question was a simple one, whether the SCA is correct to send him back to jail. To be honest, if the SCA had done the right thing and said parole is part of serving a sentence, we wouldn't be here. Because Mr. Zuma would have served his 15 months and the 5 years wouldn't have expired, and he wouldn't qualify to be a member of the National Assembly. We are here exactly because, for whatever reason, the SCA found it necessary to depart from the partial judgment, and this court also did.
Mpofu, I can see that you, having what have been on your feet for a long time, but you are seasoned counsel. I know that this is nothing for you.
Thank you, Justice.
Can I take you to, I just need to understand what your problem with us. I'm one of the judges whom your client thinks should recuse themselves from this matter. So I need to understand what is it that you're saying. You said that the fact that we have sat in matters where Mr. Zuma has been there, it's not your case.
No.
But you're saying that on the same breath, as a reasonable litigant, he has a reasonable apprehension of bias that we would then have to interpret that judgment where we then said that he must serve a period of imprisonment. Am I correct so far?
Yes, you are, Justice.
Is that not the nature of our judicial system, really? Because the nature of our judicial system is such that, for instance, if you're sitting as a judge in the High Court, when an application for leave to appeal is brought to you, the reasonable litigant believes that as a judge you are going to hear an application for leave to appeal and apply your mind, and if you believe that you were wrong, grant an application for leave. That is part of our judicial system. The same applies to a collegial court like this. Collegial court like this may sit 2 years before a certain judgment, and then another case comes before that collegial court. That collegial court then revisits a matter and says, in that matter, this court did not apply its mind to A, B, C, and D, and therefore add in that regard and change a prior decision. The same applies to rescission applications. And I know because you have brought those rescission applications. You're asking that those very judges, and I'm sure a reasonable litigant like your client would then be going to that judge to say, well, or that court, this court or the full court or full bench or the SCA, to say we're applying for rescission in this matter on these grounds. So why is it that in this matter, us being asked to look at whether the remission by the president interfered with the sentence we imposed make us biased.